time for each question, so that'll keep things moving. We'll rotate who starts first. You guys have to do a brief intro to the audience when we started here, but maybe you can do a 1-minute discussion of who you are, why you're running, and what qualifies you as a candidate. So we'll work our way down the row here. Want to start?
Yes, sir. Just remain seated.
You can stand up if you want.
Okay. Good evening, everyone. I thank you for having me here tonight. Thank you, sir. Thank you, Mr.
You got Mr. Harris.
Okay, I have the microphone now.
There we go.
Yes, my name is William Harris. I am a fourth generation Marion County. Our family came here sometime in the late 1870s and came as farmers, and our family still farms our land that we've had for over 140 years at this point. We live down on 475. I don't know how many people are native to Ocala, but we're the Gary family down on 475. I came up working in the fields like indicated. We used to grow a lot of watermelon, 40 and 50 acres worth. We used to pack the semis. We used to load a lot of hay down in Summerfield. Mindful now, that's more than, sound over 30 years ago, when there were probably 200 to 250,000 fewer people here in this county. But we worked the land. We came up hunting and fishing, something I still do to this day. I talked to some gentlemen earlier. If anyone dove hunts, we used to have a big dove hunt the first phase when the season would come in. What's that?
Am I supposed to time
Yes.
these?
Oh,
Okay.
well done.
And I gave him 15 more
I'm
seconds.
sorry.
Okay, we're gonna keep you on track.
I'm sorry.
Okay, it's all good. All good, Mr. Harris.
All right.
All right.
I'll be more forced.
Good evening. I am Judge Lori Cotton. I am your current county court judge. I was appointed by the governor about a year ago. Since that time, I've handled thousands of criminal hearings, thousands of traffic hearings, and thousands of civil hearings. Before the governor appointed me, I was a prosecutor for 20 years. I handled everything from misdemeanors all the way up to murder in adult court. I believe that judges should follow the law as it is written, starting with the Constitution on down. I believe judges should be fair to everyone and treat everybody as an individual. I believe judges should be efficient with their time and with your resources. I believe that judges should be kind and helpful to people in the courtroom. And I believe judges should hold people accountable when they need to be held accountable. But I will tell you, I also believe that sometimes rehabilitation is important, and I'm very proud to run the DUI court, which I could talk about all day, but I know she will not let me. But if you ever want to talk about it later, I will.
Yeah.
We have sufficient court.
I think we can move it out a little bit.
Yes.
Good evening again. My name is Leanne Barnes. I always have that problem. I try to talk as loud as I can. I was born and raised right here in Marion County, attended Marion County Public Schools. I'm a dual graduate of the University of Florida, majored in criminal justice and sociology, and then went there for law school. I've been practicing for 20 years. I'm licensed to practice in both state and federal courts. I've handled felony, misdemeanor, juvenile criminal cases. I've handled truancy and domestic relation injunction cases, and Baker Act and Marchman Act. Those are mental health and substance abuse cases. I'm currently the chief over my attorney. I supervise and train hundreds of attorneys in the practice of law and how to try cases and how to handle large caseloads. And I've assisted in the development of Marion County's first Veterans Treatment Court and Mental Health Court and the Juvenile Expungement Program with Community Legal Services. I'm a member of Kiwanis Club of Ocala, and I'm a member of Pace Center for Girls, 10-year board member of Pace Center for Girls. Thank you.
Hello everyone, my name is Renee Thompson. I have qualified to run for Group 1, which is the seat that is currently occupied by Judge James McCune. He's retiring. I am a practicing civil attorney and mediator. I have been an attorney for over 20 years practicing here in Marion County. I'm licensed in every district of the federal court system, Southern, Middle, and Northern. In addition, I am admitted to practice before the United States Supreme Court. I have spent my entire career working as a civil attorney in most areas of civil law and mediating civil disputes. I originally started out in a small firm of 5 attorneys. I then went on to work as a partner with an Orlando-based firm, which had over 40 lawyers. And now I have my own firm, and I mediate with Upchurch, Watson, White & Max, which is the premier mediation firm in Ocala. My background consists entirely of civil experience, and that's important, and you'll find out, is because the seat I'm running for will be a civil seat for the next 3 years. I am a past president of the Marion County Bar.
Hi, my name is Danielle Roos. I am running for County Judge, Seat 1. I have been a prosecutor for almost 14 years. I've been a lawyer for over 14 years. During that tenure, I have practiced in the civil and criminal courts. I have done civil and criminal non-jury trials for civil, and more than 40 jury trials for criminal. Currently, I am a prosecutor. I'm on a docket with Judge Hodges. I handle felony cases. I also help run the Marion County Adult Felony Drug Court Program. In my spare time, I volunteer on the Municipal Code Board, and I have 9-year-old triplets that I try and manage somewhat successfully. And I think that given all of my civil and my criminal experience in the courtroom and my experience, thank you.
All right, so the first question, we'll go to Judge Cotton and work our way back through the rotation again. How would you handle a situation, and each of you can answer this, another 1-minute question.
Can't hear you.
Okay, 1-minute question. How would you handle a situation where you were presented a case where a written statute potentially violated the constitutional rights of the individual?
All right. So I'm Judge Cotton, and let me also, before I'll take a bit of time. Mr. Harris and I are running for Group 2, and these 3 ladies are running for Group 1, so you can keep that straight in your head. Thank you for the questions. Very similar to the types of questions I got when interviewing with the governor's people. What does a judge do when determining the constitutionality of a statute? And the thing is, you look to the text of that statute. That is absolutely what you do. I am a student of Scalia. If you're familiar at all with his writing style, you know he was a heck of a writer. But also he had a way to figure out how to look at the law, and he actually has written books about this, about how to interpret the law based on the text, based on what the writer intended, and based on the words themselves and not going outside of that. The last thing you need is a judge that's making law from the bench. The text has got to be followed, and if somebody's constitutional rights are being violated, then that needs to be ruled on that way appropriately.
So I definitely have to agree with what Judge Cotton said. You have to look at the text of what's presented before you. And one thing you have to remember in asking that question is a judge cannot make their own ruling based on what they feel, based on their opinion, or based on what society feels. It's based on that rule of law that's before them. And as a supervisor over my office, I've had to make hard decisions that wasn't the popular decision, and that's what a judge has to do at times. You're gonna make rulings that are not popular in a community. And I will be the person that will not falter based on what the law says. And I will make sure that I am fair and I am impartial.
Part of the job of the judiciary is to rule on difficult matters, of course. But I too am a textualist. It's important that you realize when you're reading statutes, when you look at the law in front of you, that it has a purpose. And if it's unconstitutional, it's your job as a judge to let the individuals in that case know and to uphold it in a way that can be not only gleaned as constitutional as possible, but if it can't be held, then you have to deem it unconstitutional on its face. And that's not an easy position for any person to be in, right? But in county court, I will say, constitutional issues, ruling something unconstitutional is a very rare thing for a county court to do. but it's important that you know that the person before you will do it. And I am that person. I will follow the law.
Very good.
Hi, Danielle Reese again. I have to agree with everybody because we really can't, the bench cannot bring their opinions or their beliefs into their rulings. They absolutely have to follow the law. And if there's a situation where one part of the law conflicts with the Constitution, then you need to research and study and look at what the text says and try your best to make a ruling that is fair, legal, and follows the rules. And if it's not popular, that's just something that you've got to do as a judge, and that's something that you've asked to do as running for judge. So,
You all have probably heard pretty much all the type of answers that can be provided with that. I will say, I'm a former prosecutor for 12 years. I currently work for the county attorney's office. When I was a prosecutor, there was one issue on a constitutional matter that came before a county court judge. It had to do with interpretation of a county ordinance. And the opposing counsel was arguing that the county ordinance was unconstitutional. There was a technicality that was utilized to get the favorable result for their client, but I thought I was correct. And everyone has said all it can really be provided as an answer to this type of question. Scalia was a textual. I think pretty much all of us here follow that principle. I was one of the persons that went to the governor last year. That same question was asked regarding interpreting a particular statute or ordinance and the constitutionality of it. It's something that, as candidate Bruce mentioned, not something that's commonly in county court, but it's one of the major issues that you hear about in the news, particularly now with Roe versus Wade.
All right, we would like to get each of your views on what type of authorization is necessary to enable an administrative agency to create laws. So when you're faced with a law, at your court that has been created by an administrative agency, how would you determine if that was a valid administrative law?
Okay, we've got to understand the question. You said
You're faced with a regulation or a law that has been promulgated by an administrative agency. What is your views on what authorizations are necessary for the agency to create a law or to be able to have that power?
Well, I do know that there are a lot of things that we face when we have like the open container. When you have the like open container laws or whatever else that are produced not by what's in the law books.
Yes.
And we have to follow those same laws that are before us. And I think it's the same thing that you deal with when you're dealing with the laws and the statute. You just have to follow what's printed and what's before us. A lot of times we deal with administrative orders and we have to just follow what's there.
Sir, we are having a really hard time hearing anything that all these wonderful people say.
All right,
We are lifting the speaker up on the table.
all right, let's try to put the speaker on the table. Let's try that.
There's two speakers.
Okay, where's the second speaker?
Just hold the mic.
Yeah, both of them.
They're holding.
They're holding one
I'm used to talking with my hands, so I can never.
Yeah.
You could link them maybe.
Yeah, they link. Is that on?
Get them away. There you go.
It's not the speaker. They're not holding the microphone.
Is this okay?
I can hear you.
Yeah. Okay.
We can't hear Barnes.
Can you hear that if they hold the microphone closer, or is that still not
It's
working?
fine.
Somebody's phone's gonna get into it.
Great. Can you try?
Does this work?
Yep.
Nope.
That came over the speaker.
You can hear it?
Yep.
Yes, now.
Okay.
And you said.
I'll try to speak up if that helps. Fantastic. No one ever accused me of being a quiet person, so this will work out well. So one of the things that was asked was whether or not an agency, how you would rule on whether an agency law is valid. Is that correct?
Correct.
Okay, I want to make sure I understand the question. Much like a statute, when you're dealing with legislative intent, you have to look behind it to see what exactly was enacted and why it was enacted. But like any regulation, you are required as a judge to follow that. So despite your personal opinions, whether you agree with that, you are required to enforce that. So I say that because I think sometimes, especially in today's world, we forget this doctrine of separation of powers. And we have to remember that when the legislature makes law, the judiciary has to follow that law. So it's important that you realize that we are within constraints and bounds of what is brought to us. We don't get to say whether or not we like something that happened from the legislative issues or from an agency. If it's a valid agency ruling, or if it's a...
I feel so rude.
Sorry, I want to apologize real quick. I'm used to having mics everywhere, so in court, we don't speak into a
Hold it to
microphone.
your mouth.
We speak to the room, and the room picks up the microphone, and it goes over in all of it. Like Ms. Thompson was saying, as a judge, it's not my or anyone judge's job to create law or to modify law. It is to follow the law. And if the legislature has handed us a law, it is our job to use that law as a tool. We're not allowed to change it. And as a judge, that's what I would do, is follow the law, enforce the law.
I will talk quickly if I can. So the fact is, when a law is enacted, whether it's a statute at the legislative level or at the county level where I work, it's an ordinance. It is, and there's case law on this, basically decisions by courts. It's clothed with a presumption of correctness. That's the term that the courts have used. Basically, you can enact a law. It can be a stupid law. In this case, there's commentary about that. But it is still the law that must be followed. I don't know how many people are hunters in here or fishermen, but if you go hunting, there's a limit of how many deer you can take. You can say it's unconstitutional, but until a court ruling determines that it is in fact unconstitutional, you have to follow the law. There's any fishermen. There's a cap on how many fish you can take, whether it's tail, snapper, or whatever it is, there's a cap. That is an administrative body that has promulgated a rule that must be followed. And until there is a higher court decision that invalidates that, then that rule stands. Thank you.
All right, well, I actually litigated an administrative rule one time. Now, it's not something you see very often in county court, but I saw this as a young prosecutor. Are you familiar with intoxilizers that people blow into when they're accused of DUI? Well, there are rules put out by FDLE, which is an administrative body, and that those rules are what allow law enforcement to use the intoxilizers as a tool to measure alcohol in somebody. Now, the situation we had was there was an agency inspector, I remember his name still, it was Bird, at the sheriff's office, and he had failed to get his proper training and able to do the inspections. And then he kept doing the inspections. And then, of course, defense attorneys saw that this was happening, and I litigated all of those cases together. And what you do when you have that situation is you look at the agency's rules themselves, and you look at any guidance from other higher courts who have already interpreted those rules. And in that situation, the key was there substantial compliance with their own rules? And because there was, it allowed those results to be used in those cases.
Okay, let's get a little more into judicial philosophy. What do you believe the role of the court system is in creating new rights for citizens?
I don't believe that it's the court system's role to create new rights for citizens. I believe we were handed a constitution, and that is the constitution that we're required to follow. Those rights are enumerated in that document. And it's my job, if I'm elected, to make sure that those rights are then properly executed throughout the manner in which I carry out my orders and my rulings. I don't believe it's a job of the judge to be an activist. I think that you have to be very disciplined when you are a judge. You not only have to be fair, but you have to read the Constitution on its face, and you have to apply it on its face. So I do not believe it's the role of a judge at all to create new rights for citizens in any way, shape, or form.
Creating new rights is not something that the judiciary has any business in handling. That would mean bringing into the courtroom some beliefs and some opinions of mine or any other person that are mine. And the role of a judge is to leave their opinions and beliefs at the door and to follow the law. Follow the law strictly and follow the Constitution. It is not our position to change any of the rights that people have just based on a case or a whim or our opinion, our personal opinions. So I don't think that there's any place in our judiciary or in the courtroom for creating any rights whatsoever.
That's an interesting question, particularly for county court, but I would advise that, it's an interesting question, partly because I was changing out automatic water for the cows the other day, and I was listening to Scalia on my phone, and he was discussing the evolution of substantive due process rights, where basically the courts have created, in his mind, and I think many people's mind, these kind of legal fictions to create these rights that are now becoming embedded in our case law, starting with the Warren Court, going back to the 60s. These are issues that, well, that may be in county court that are litigated. They will be in county court. I don't know if they'll necessarily be litigated matters, but we have gone a long way into creating some of these substantive due process rights, and I don't think necessarily they're going to be solved by what comes out of county court per se. Once again, the Roe versus Wade matter is something which kind of evolved from some of these issues that the courts created.
Can we have everybody say their name each time you go up so we know who you are?
Sure, Lori Cotton. Just remember, 100% cotton. All right, so I will tell you, as judges, we are not allowed to talk about current events, so I'm going to stay away from talking about any particular cases or anything that might be being decided, especially by higher courts right now. But one of the points I want to talk about with rights is a lot of times we say, you know, the amendments give us rights. The First Amendment gives me the right of free speech. You hear that all the time. That's not what the First Amendment says. The First Amendment takes away the government's power to restrict your free speech. So what? So if you look at the Constitution and you look at the way our law is designed, the people have the power.
That's right.
And then the document is designed to restrict the government's power. Now, I agree with what my fellow candidates here have said, that judges should not be creating new substantive rights from the bench, especially not in county court. But we do have to keep in mind what the Constitution says, and that says the people have the power. It says right in there, whatever powers aren't articulated are reserved to the people or the states respectively. That's exactly what it says.
I have to agree with Leanne. I have to agree with Judge Cotton indicated. One thing we have to remember is, again, from the beginning when I started talking, judges cannot create law. That's why we have a legislative body. That's not us. So we don't create law. And I have to agree with what everybody else is saying. When you're on the bench, it is your job to take the law that's in front of you. You should not be creating it. You should not be giving your own opinion about it. You have to go with what's in front of you. And if somebody wants the law changed, don't come looking to the judge to do it. There are other avenues.
So, yeah, this will be your question.
Okay.
So, if elected, what would separate your court from others? What would you do differently as a judge, or what would separate you? What would be kind of your brand as a judge?
I think that something that I would bring and have a unique court with is my ability to work well with others. Part of being in a courtroom and part of working with so many different agencies is being diplomatic and working together so that you do not waste taxpayers' money, do not extend things over long, don't bring your opinions in there, make it fair, impartial, and make sure that you do the job as described, as you were voted in to do, and not to bring any other personal dilemmas or prejudices or any of that into the courtroom. And I think that my courtroom would be known for that, knowing to work hard, get the work done, do it efficiently, kindly, and following the law.
Say your name because there's.
William Harris. I think what I would bring to the bench is temperament. My temperament is such where, in demeanor, I think I remain calm in all situations. I can advise you. I've worked in private practice, started out in Brevard County working there, dealt with criminal defense work, eminent domain matters, business litigation, just pretty much dealt with anything that might come in that courtroom. So I have the perspective to understand